Hey, you guys! How's everybody doing? So the good news is my meeting today ended a little early. The bad news is they want to start the meeting a little bit later Mondays moving forward. So we'll have to, I'll let you guys know what Mondays are going to look like moving forward, what time we'll get started. It seems like today there's been like an hour plus of downtime, so we will get caught up. We will be watching day 148. But since they have a ton of breaks anyway, it's my understanding that they're waiting for a juror. I thought we could look at the written response from Brian Steele in response to the state's motion to reconsider the oral order striking retired Detective Dennis's testimony and related exhibits. So this was filed, you see it marked, it says midnight, like right on the dot. And I know we're going to hear this argued orally, right? We'll get caught up. We'll hear all that stuff. I'm looking forward to it. But reading it, there's some extra snark and some stuff we don't always hear in the oral arguments. So let's see. Make this bigger. Make it easy to read. If you guys want to read it on your own, pasting the doc link in the chat and I'll add it to the description. But what do we got? Comes now Jeffrey Williams by and through his undersigned counsel. Hereby files this motion to the state's motion for reconsideration of this order striking Dennis. In support of this response, Williams shows as follows. Mr. Williams is innocent of all charges in the above referenced indictment. Retired Detective Dennis has been called to testify on approximately 4 separate occasions in this case. The first 3 times, Detective Dennis was cross-examined. On Thursday, October 17th, 2024, retired Detective Dennis was testifying on direct examination. Retired Detective Dennis was asked whether co-indictee Kendrick agreed to speak with law enforcement after being read Miranda rights. Detective Dennis answered no. This was met with an immediate, timely objection and a curative instruction by this honorable court that retired Detective Dennis could not legally comment on an individual in custody invoking his constitutional right to remain silent. So there is a specific there, right? We're getting the context of October 17th. This honorable court gave the benefit of the doubt to retired Detective Dennis that his improper comment on post-arrest silence was a misunderstanding. The timely motion for mistrial was denied by this honorable court. A short time later on direct examination, retired Detective Dennis was asked about a photograph placed in evidence, depicting Mr. Kendrick standing on top of a vehicle purportedly possessed by Mr. Bennett. When asked to orient the jurors to this exhibit, retired Detective Dennis improperly, intentionally, deliberately, knowingly, and willfully poisoned this trial by announcing that Mr. Kendrick was released from prison a short time before this photograph was taken. There was an immediate objection based upon violation of OCGA 24-4-404A, bad character, and motion for mistrial based upon the second highly prejudicial and improper gratuitous testimony by retired Detective Dennis. Now remember when we were watching the court feed that day, whenever they had an exhibit up on the screen, we couldn't actually hear the audio. The audio wasn't coming through to the media pool. So this is spelling out the details of what we were just kind of trying to piece together from reports online. It was established that retired Detective Dennis is at least a 10-year veteran of the City of Atlanta Police Department, has been accepted as a gang expert in this case, has testified multiple times in this case, and therefore, it was clear, even to a casual observer, that retired Detective Dennis intentionally and wrongly put this case in jeopardy of a mistrial. This honorable court denied the second motion for mistrial and instead ordered that retired Detective Dennis had forfeited his right to continue to testify, as he was intentionally, obviously, and wrongfully violating elementary, foundational rules that any law enforcement officer, but especially a seasoned veteran, should have obeyed when testifying in a criminal case. Now, did you guys, we knew there was something was going on after that picture where Yak was standing on the vehicle, but I don't know if it's just slipping my mind, but I didn't really remember catching this first motion for a mistrial. So remember when Whitaker was snapping, I'd like to admonish him myself, talking about Dennis. It was probably because minutes or so before this whole instance with Yak standing on the car and he makes this utterance that he had just gotten out of custody, Whitaker had to clear this all up. So, and then he does it right away. Since retired Detective Dennis was no longer a testifying witness in this case, Mr. Williams and the other individual on trial never had the opportunity to cross-examine him on his fourth round of testimony, and Mr. Williams then asked that the entire direct testimony of retired Detective Dennis, all exhibits, and jurors' notes be stricken. The prosecution's motion for reconsideration, emailed at approximately 9:02 p.m. on Thursday, October 17th, 2024, argues that there is, and this is important because the state never does anything this quickly, but they filed this super quickly because they needed Dennis. They wanted Dennis to come back. They want Dennis to continue to be able to come back to the stand whenever he pleases, whenever they please, to testify how they want him to testify. But they argue that there is no constitutional or statutory right for this honorable court to strike the testimony of retired Detective Dennis. As discussed above, this argument is off base, as Mr. Williams et al. Right to confrontation would have been violated if this direct testimony, exhibits, and jurors' notes were not stricken from the trial. Specifically, because Mr. Williams et al. Did not have the opportunity to cross-examine retired Detective Dennis during his fourth round of testifying, based upon retired Detective Dennis's failure to comport with critical, material, and foundational rules of a trained, sophisticated law enforcement officer. Oh, this is such good shade. The confrontation clause would have been violated if the direct testimony, including all exhibits, jurors' notes, were not stricken. And we get this cite here to State v. Stevens, where testimonial statements are at issue, the only mechanism to properly judge credibility and to satisfy the constitutional demands of the confrontation clause is the opportunity to cross-examine. In this case, since the Honorable Court denied the motion for mistrial, but crafted the permitted sanction of prohibiting the permitted sanction, so this is just a slick way to argue, the court was allowed to make that sanction contrary to what the state wants to argue, of prohibiting the witness's direct testimony to go forward based upon fear that the witness would continue to intentionally thwart the obvious and elementary rules of evidence. Cross-examination did not occur, and since there was no opportunity for cross, that is the reason that the witness's testimony, in toto, was stricken from the record. The striking of testimony on direct examination was lawful, just, and mandated to cure the violation of Mr. Williams et al.'s right to confront the witness. So, if you reconsider this and undo this, there would be a bigger problem, a constitutional problem. The right for these defendants to confront this witness. So, even though what you did was permitted, the state's arguing that it should not have been permissible for you to do this big sanction. If you undo it, you're going to run into a constitutional problem. So, your hands are tied, court. Thus, the prosecution's argument that the stricken testimony... thank you for the super chat, but we're gonna get there, you guys. We're gonna get there. So, common sense would tell us that this has already been ruled on since they did these arguments this morning. But we're looking at it because we get certain arguments and certain details that we don't get from watching oral arguments. So, that the testimony was not connected to a statutory or constitutional violation is not correct. So, the state just dumb argument. When a witness testified at trial but was unavailable for cross-examination, the 6th and 14th Amendments to the United States Constitution and the corresponding sanctions of the Georgia Constitution and Georgia statutory law are all violated, and thus striking the witness's direct testimony in toto and instructing the jury to disregard the entirety of the non-cross-examined witness's testimony was lawful and cured the 6th Amendment violation and avoided a mistrial. Now, this is very complimentary to Judge Whitaker here, which I think is strategic, right? You don't want to harp too hard on the judge saying what she did was wrong, because she's probably not going to want you to argue that. She just wants you to argue what case law is there that this shouldn't be reconsidered. Further, the prosecution's motion for reconsideration is an inappropriate vehicle to challenge this honorable court's action and is a misnomer for the reasons below. And remember, it was Kevin Armstrong that wrote that motion to reconsider. The prosecution did not make a timely objection raising issues articulated in the 9:02 p.m. Thursday, October 17th, 2024 email attaching the motion for reconsideration. All of the arguments contained in the motion for reconsideration are time-barred because they do not request the reconsideration of issues timely raised, but are new propositions of law not previously argued by the state. Now, this is really interesting because this is something like, this just seems like such a Brian Steele argument. Like, the technicalities, the nuance, by the way, here's this other argument. Thus, this is not a motion for reconsideration, and therefore this motion is not timely because it is not made at the time that the objections needed to be voiced. So he's like, this is technically a different mechanism, and it's not appropriate. It's not appropriate to call this a reconsideration. This is such a Brian Steele argument. The contemporaneous objection rule provides that counsel must take exceptions to the alleged error at the earliest possible opportunity and state the specific reasons for the objection. And he cites Birch Property Apartments v. Simpson. Specifically, under our, quote, new rules of evidence, the contemporaneous objection rule provides that counsel must make exception to the alleged error at the earliest possible opportunity in the progress of the trial by a proper objection made part of the record. And he gives Torres v. City of Jonesboro. Like, this is just so Brian. The state's motion for reconsideration injects new theories of why this honorable court supposedly committed error, and thus is untimely, and hence there is nothing to reconsider, as the state has waived these objections by failing to raise them timely/contemporaneously. Additionally, in Illinois v. Allen, our highest court articulated 3 principles regarding courtroom decorum. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings. The flagrant disregard in the courtroom of elementary standards of proper conduct cannot be tolerated. Trial judges confronted with contumacious, stubborn, defiant witnesses are vested with sound discretion to meet the circumstances of each case. Striking the testimony of a witness is a drastic remedy, which is not to be lightly done. However, this honorable court properly exercised its power and authority to attempt to keep. Oh, words are so important, you guys. This honorable court properly exercised its power, good job, Whitaker, and authority to try. So we're not saying you succeeded, although you did everything within your power. That's like the best way you can compliment the judge while also saying, still don't know if you can fix this trial, but you're the best one out here to be able to try to find a way. Like, that's such a great way to compliment somebody, coax the ego, without, conceding that everything is fine. To keep this trial constitutionally and statutorily fair. In California v. Navarrete, the California court was met with an issue closely mirroring the state in the case at bar. So we're going outside of, our circuit here, but this case matches really well. Why does this case match so well? Specifically, the prosecution called a detective. So we're dealing with a detective who probably knows how to testify. That's very similar. Who testified and impermissibly commented on Ms. Navarrete's in-custody statement. So we're getting a defendant who was in custody at some point, the detective comments on it. Very similar. That was deemed inadmissible because it violated the requirements of Miranda. The sister trial court, sua sponte. So at this court, the court stops. The defense doesn't object in this situation. The court says, whoa, 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 whoa. Interrupts the proceeding, called counsel into chambers, demanded the prosecutor to explain, what do you have to say for yourself? And the prosecutor replied that he did not expect the detective to answer in that impermissible manner. And this is exactly how Hilton explained herself. But we didn't expect him to give that answer. The defense lawyer moved for a mistrial based upon the detective's reference to the suppressed statement, but the trial court denied that motion for mistrial and instead crafted the sanction that the detective's testimony would be struck in its entirety and that the detective could no longer testify on the case. So there was a motion for mistrial, but the judge in this same case said, no, but we're going to strike the testimony and the detective's got to go. So point for point, this is very similar to what happened with Kendrick, Doug Weinstein, Hilton, Detective Dennis. The trial court then returned to the courtroom and instructed to the petite jury that the detective was excused. The jury must disregard the detective's testimony in its entirety, admonished the detective, and prohibited him from further testimony in the case. The prosecution then called its next witness. Interestingly, the Court of Appeals in California, 2nd Appellate District Division 8, held that the sanction preventing the detective from testifying further in the case and striking of the detective's direct testimony did not go far enough to ensure that a fair trial was available based on the deliberate, highly prejudicial conduct by a trained law enforcement officer. And this misconduct mandated a reversal of Mr. Navarrette's convictions and sentences. Whew! Great comparable case, and it's not... When you can find something in another circuit, it might not be binding in and of itself, but it can be highly persuasive. And when it matches these details across the board, highly, highly persuasive. As shown above, and I think we're wrapping this up, so we'll get into the arguments from this morning. We'll start playing the trial stream. As shown above, this honorable court has considerable discretion, which is true, to control this trial to ensure fairness and the orderly administration of justice. See Jackson v. State. It is the duty of the trial judge to control the trial of the case to ensure that a fair trial occurs on the disputed issues, and that this honorable court has considerable discretion and power to control and meet these constitutional guarantees. Respectfully, this honorable court should deny the state's motion for reconsideration as untimely and not legally correct. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, asks this honorable court to deny the state's motion for reconsideration as same is not timely, not based on accurate facts, and not supported by case law or constitutional and statutory provisions applicable to this matter. And we've got a footnote. Moreover, it appears, we're ending this with a footnote. Moreover, it appears that much of this motion is deemed moot as the state on Friday, October 18th, 2024, over defendant's objections and continued objections, is, quote, redoing the testimony of retired Detective Dennis with Detective Underwood. For this additional reason, the state's motion must be denied. So we put this common sense extra argument down here as a footnote at the very end. Man, shout out to Brian Steele. Shout out to Keith Adams too, because I'm sure Keith Adams had a role in this. But what do you guys think, guys? This is why we go back and read these things, because we'll see some of this argued orally. But there's some stuff you get from reading this that you won't get from, with oral arguments. You want to be concise. You want to value brevity. We might miss some of the stuff that's in these written responses here. And I loved this all the way through. I loved the extra, to me it was like a left field, never expected an argument, but I'm sure Brian Steele, it was like common sense in the moment it was happening when they didn't object in that moment or didn't raise their issues. This, it wasn't timely. So to see that additional argument in here, I was like, oh, good lawyer there, good lawyer. So what do you think? Rate this on a scale 1 to 10, with 10 of course being 10 stars the best. What do you guys think? Drop this link for you in the chat and put it in the description. And we can get on over to this actual trial day. We'll be able to catch up, you guys. Switch over to